You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
Welcome back, members of the jury, to another episode, and today we have a fantastic trial breakdown with a frontline freedom fighter, as always. And this case is really special because in our line of work and our profession across the country, there's a negative stigma, I think, that exists as it relates to public defenders. There's a really nasty phrase that I personally hate that goes around some offices and courthouses, which is known as a dump truck. And that's a public defender who all they do is plead out their cases and they never take a case to the box. And as we've said before in the show, there's two main reasons why you would take a case to trial. Because you as an attorney know that the opposing counsel can't meet their burden, or because they're just being too unreasonable with their ask, or you see more in your client as a human than the other side. And so our guest today, in a case where his back was against the wall, facing a client who had been in and out of the system, was commonly known by the prosecutors, the courthouses, and the public defenders. In a situation, would it be real easy to just be another dump truck and plead out this client and have the revolving door continue? He stood up against the odds, and he took her matter to the box. And we're going to learn how that one day in court and that fight changed this client's trajectory going forward. And so with us today is a fellow public defender and my forever bash brother, Deputy Public Defender Derek. Derek, please introduce yourself to the members of the jury.
Lucas, thanks for having me, man. Yeah, my name is Derek. I'm a public defender, been with the office for about 4 years now. And yeah, this trial was definitely one of my most memorable and definitely filled with all sorts of crazy things.
Well, we're excited to get into it. And why don't you just go ahead and give us a quick rundown of what the client was looking at, what kind of the charges were, and what was essentially the prosecutor's quick theory of their overall case.
So client, as you sort of mentioned before, client was in and out of the system at a misdemeanor level for about probably 4 or 5 years. She had multiple arrests, dozens of arrests, sometimes days apart, all of them for low-level, petty misdemeanor crimes, most of them related to being transient, being homeless, encroachment, unauthorized lodging, possession of narcotics or narcotics paraphernalia. There was never any violent history or any history like that. It was all very low-level misdemeanor charges. And in my particular case, she was looking at what started at 5 misdemeanor charges, 3 of which were for vandalism under $400. And then there were 2 drug-related charges, of possession of paraphernalia and a being under the influence. And the prosecutors actually amended the complaint prior to trial to add, I believe, 3 more vandalism counts and a possession of tagging tools, all misdemeanor counts.
And I just wanted to take a moment to explain. I'm sure a lot of people who do listen to the podcast are familiar with an amended complaint, but every now and again, I think we get a new listener who maybe not be as familiar with some of the jargon that we use. And basically what happened was when the prosecution originally filed the complaint, they looked at the police reports and thought that they could prove X amount of charges. And then as a sometimes strategy and trial tactic, they'll, as the case progresses and gets closer to trial, or even on the day of trial, they'll add charges based on the same conduct and police report that they think that they can prove, whether it be, extra damage or a different incident date. And oftentimes it won't even change their offer, but it will change the exposure that the client has, which is why they use it as a tactic to try to force a plea. And they really do it with those that, they're kind of just tired with, of seeing the same client go in and out of the system. Right, Derek?
Right. And in this particular case, the charges, the vandalism charges, the district attorney that was in charge, or that was prosecuting the case, she had actually gone out after they had filed the original complaint. She had actually gone out afterwards to this part of town where this incident had taken place, and another member of the community who was supposedly a witness to this vandalism, and a police officer, they had gone back to this area of town and had taken pictures of what they believed to be my client's graffiti. And they then gave me that information a few days before trial with the amended complaint, telling me that they were going to be adding these charges. So it was something we had to deal with just a few days before trial about these new allegations on top of what they had already alleged.
And so after the prosecution decided to amend the complaint, did that change the case's trajectory on its way to trial, or did things continue?
No, it didn't really change the trajectory. With this client, it was really trial from the beginning. When I first met this client in custody, I could tell she was going through it. She looked extremely rough. You could tell there were obvious signs of struggling, of homelessness, and someone who was scared of not only the system, but of the police officers who had arrested her, which actually played a big part in the trial. But at the time, the first time I met the client, we decided then and there that this was going to be a trial case, not only because the situation she was in, as well as the charges, but the officers involved. Client really wanted to make a point with this trial and really wanted to get the officers on the stand and make some points about their treatment of her and other homeless individuals in the community.
That's a really great segue to where I want to take us next in the conversation, because I know we had an opportunity to speak before we started recording. And, that takes us into the very first element or phase of a trial, which would be the motions in limine. And I know you were mentioning that one of the kind of battles that you had in this case during the motions in limine was whether or not you were going to be able to admit certain evidence against those police officers. Why don't you give us insight as to those in limine arguments?
Sure. So in this particular part of town that the incident had taken place in, there's a specific police unit that handles the homeless individuals. And this office or this unit of the police office says that they are very proactive about, handling homeless issues and helping the homeless. But a lot of times what we found out is that they're actually harassing them or over arresting them. And that appeared to be the case in our case. The officers initially these officers were harassing her, and that they had continually arrested her dozens of times. And so when I looked into it a little bit, and in the system that we use, I was able to find a list basically of all the times that my client had been contacted by the police. And when I started digging through this list, I found that it was the same two officers every time that were arresting her. Sometimes with 3 days apart, sometimes 5 days apart, sometimes 2 weeks apart. But it was always these same two officers listed. And so, at first, a little skeptical.
Well, also real quick is that obviously the police departments have certain departments and divisions and units that patrol a given area. And so it's expected to see somewhat of the same officer's name every now and again in different reports and within the same area. But it's another thing when you're seeing it in that abundance of amount with the exact same officer. That's way more past than just a coincidence, right?
Right, right. And we're not talking, 3 or 5 or 6 times. By the end of looking through all these records, I had printed out 22 separate incidents within a span of, I believe it was 18 months or 19 months. So averaging a little bit over an arrest a month of this person by these same officers. So that's a high amount. That's not just stopping someone occasionally. That's above and beyond what I would feel and what I have seen is normal in even in the transient community, which does get contacted by police more frequently than those who aren't homeless. But yes, that was
Yeah, but that's them. That's them looking for her.
yes, exactly. And it turned out that it was actually true.
As you went through the motions in limine, did the judge permit you to admit that evidence?
Yes. So, long story short, yes, he did. He wouldn't let me because I had to print out from the computer system these records. There was an issue about getting the actual records into evidence because of hearsay rules, certain rules not allowing for certain writings without the author being present. So what the judge did was allowed me to cross-examine the officer based on the information in the reports. And if the officer were to lie or were to go out of the bounds of what was on the papers, I would then be able to present those to him and impeach him with those.
Well, good for the judge. That's, in limine rulings, I feel like don't often go our way. And so when they do, that's a huge victory.
And this judge, I should preface, he's a very old judge. He was quite a stickler on the evidence rules, but ultimately we did get the ruling we wanted.
Well, that's fantastic. And I think we're excited to see when we get to that cross-examine portion of the podcast, how you were able to utilize that evidence. What I want you to do first is take us to the openings. Give us a breakdown as to the picture that was painted by the prosecution during their opening, and how did you try to rebut that with yours?
So the prosecution's opening wasn't amazing. It was very straightforward. That's being nice. I didn't think it was very good. Not a lot of emotion. Their theory of the case was what I thought. They wanted the jury to look at this incident, see a homeless lady, see that she had been in trouble in the past, or just look at this lady, see how bad of a person she is, and sort of overlook the small details, right? Our theory, on the other hand, was we have to look at the details. We have to analyze everything, not just pieces of information, but we need every part of the story to know the whole story. And in order to point blame at someone, we have to know the full truth. So my opening theme was the search for someone to blame is always successful, but that doesn't make it just. And when I said that, I realized it's sort of an intellectual type theme. It's not an easier to understand, but what I meant was it can be easy to blame anyone, right? You can point fingers at anyone. It doesn't make it just, and it doesn't make it right until we go through the evidence, and until we take a look at everything. We're not going to actually know the truth. So that was really where I went with the theme. It was pretty obvious from the beginning of the prosecution's opening that they were going to rely on simple facts. They did not want to get into client's story. They didn't want any sort of sympathy. They wanted, I think, the members of the community to see a homeless individual and assume that because she was homeless and because she was found with a shopping cart that did contain some art materials, that she was automatically guilty, that there's no one else that could have done this vandalism.
Or any other reason as to why she would possess, those kind of materials. So we obviously know that the prosecution are going to try to paint the client in the most negative light that they can. And I know in this case you mentioned that this was after the amended complaint ended up being about a 10-count complaint with multiple counts of vandalisms, the possession of the tools, and the paraphernalia and drugs. I want to get into the prosecution's case in chief and have you explain to the members of the jury how they went about trying to prove this case, what witnesses they used, and what kind of testimony they were introducing into evidence.
Sure. So the first witness that the prosecution called was the police officer. One of the police officers. There was two police officers involved, and really, as a little bit of background on what she was or what was going on at the time, the officers had contacted her near a wall. It was a wall that had already had a bunch of markings on it, a bunch of graffiti on it. It had paint all over it from what's called buff paint, from when they paint over graffiti in the past. And she was contacted at this wall by these officers. And when she sees the officers, she immediately runs. According to the police officers, well, according to the district attorney's theory of the case, she ran because she was guilty. She ran because she was scared of seeing these officers again, and not anything to do with the writing. So when the officers get closer to where she was before she had started running, they said that they had seen some graffiti. They said they had seen one piece of graffiti, a marking on the wall that had client's nickname. Client was semi-known by this nickname, but the picture that they had given to back this up, that the officers taken, was blatantly not the nickname that they had said. And this was really what had tipped me off in the beginning, when I was at the very beginning, before I even had met client, when I was reading the police reports, was that this photo that they were giving did not add up with what they said, the tagging said. And I have somewhat of a background in drawing graffiti. So I'm able to read the letters probably easier than your average person, given that I've drawn it before, and I'm somewhat familiar with the culture. So that was really the first tip off that something was up, because what the picture they had given did not match up with what they said it had said. And I could read it blatantly, but that was ultimately an issue for the jury. And in their case in chief, the prosecution decided to go over that with the officers. They entered the photos and stuck with the story that this was her graffiti, along with some other photos that they had given.
Well, I know visuals can always be pretty damning evidence when the prosecution are able to get it in, and so it seems like it was actually, in a rare sense, to your benefit, since now we know you had a hoodlum background and engaged in youthful graffitiing. But that's amazing how those experiences come into play and ultimately make you a better defense attorney in the moment. And so I think that that's a great segue into your opportunity into cross-examination. How did you utilize that knowledge of graffiti and the arts to disprove what the prosecution were trying to say and more or less discredit this photo that they were trying to admit?
Well, it was a pretty long cross-examination, I was able to use a lot of the different body-worn camera footage that the officers had to take still frames of the different things that they had said was my client's graffiti. Ultimately, in crossing the officer, we were able to get him to admit that about what he had written, saying client had written. That doesn't make a lot of sense. Okay, so in crossing the first officer, the first thing that we really wanted to show was that they never actually witnessed client vandalize anything. Everything was circumstantial, right? They weren't witness to her drawing or her painting or her writing on anything. Everything was secondhand, right? So we were sure to make that point up front. We then went into a little bit of his contacts, and I wanted to start out with that early because I really wanted to get the jury on our side to understand that this wasn't, an amazing officer that had never, done anything wrong or anything like that. We wanted to paint a picture of an officer who was harassing this woman, him and his partner, for months on end, and really taking policing too far. And so we were able to establish that they had patrolled the area often, that they had seen her, that they had arrested her before, but that they also knew that graffiti in particular, that was an issue in that area of town. So in entering some of the exhibits and talking to him about the picture, the initial graffiti incident, I asked him a lot about whether or not he knew what client's handwriting looked like, or if they knew if he had any formal training on handwriting to be able to say that it was my client's handwriting that had done the graffiti. And he testified that he did not. He didn't have any training on anything like that.
What about some of the, I think, more basic facts that one would think would be present when catching someone in the act of graffiti? Like, were they able to establish that client was in possession of a paint can, that client had wet paint on her clothes or on her hands? Did any of that stuff get established?
Well, yes. So they were able to establish, and when client was contacted, she was found with a big cart, all sorts of things in the cart. Basically, her whole life was in the cart, and it was a sort of it had fur all over the sides. It was a pretty animated cart, but she did have all sorts of art supplies in the cart as well. She had markers, she had pencils, she had oil coloring. She did all sorts of art in this particular part of town. And she also had canvases, paper, things that you draw on anyway. Now, what they charged her, they ended up adding the possession of tagging tools for the art that she had in her cart. Now, with that specific charge, you cannot, it's sort of a vague charge. Really, you just have to be in possession of any sort of tool that can be used for tagging. But they did ultimately charge her with that. And they did find in her cart what could be considered tagging tools, basically just instruments of art.
Yeah, they can also be used for other purposes besides tagging tools, or at least one would be able to argue that. Do you recall how many witnesses you ended up having to cross-examine? Was it, both of the officers that were, had been harassing your client? I know you had mentioned there was at least one witness to one of the crimes. What exactly were you facing during your cross-examination?
We had the two officers, we had two witnesses, and then the prosecutor actually called an expert for the methamphetamine, the pipe, and the under the influence as well. So we had an expert, two witnesses, and then two police officers.
Now, I know you mentioned that the prosecutor during their case in chief had at least one photo and aspect of media evidence that they admitted. Did you have any media that you utilized during your cross-examination, or were you really just focused on discrediting and poking holes in the media that the prosecution, had introduced?
Yes, we used a lot of different body worn clips. I also had my investigator go out and take photos of the area just to show how much different graffiti was there that was not alleged to have been my client. Really, one of the biggest things about the body worn that we used was, luckily, in case the officers did not turn off their body worn during the encounter. So we were actually able to see and hear a lot of what they were saying, which actually ended up playing a very big part in discrediting these officers, because in some of the clips you could hear them saying certain things that were not good for them.
That showed how they had been prejudicial and targeted and borderline harassing the client. Yeah.
Yes. What the body worn had shown, and this was something that we had seen from the beginning, which also added to my client's claim that these officers were harassing her, was in the beginning, when the officers are approaching her, you can hear one of them say something along the lines of, "I told you she was going to be over there," indicating that they had already been talking about her, and that they were sort of looking for her already. And so we had that, and we had brought that in. And there was another part after she had ran, when she sees the officers and she had ran, they run back to their patrol vehicle, and in the body worn, you can hear the officer say, "Oh, it's got to be her. Oh, it's gonna be her. I should have just cuffed her, and then we would have figured it out." And what that ended up being a very big part of our case and our theory against these officers, because again, it was sort of this shoot first, ask questions later mentality that not only the DA was doing, but that these officers were doing. Cuff her first and then figure it out. And that's sort of aligned with this theme of the discrimination against this community. Arrest them first, let them figure it out in court. Charge them first, get them out of there, and then they can deal with it. And to actually have video evidence of these officers saying things like that was really powerful. And in opening, I told the jury, you're gonna hear these officers say things. And I started early on warming them up to things like that, about looking at cops through a critical scope and through a critical eye. And while it's very prevalent right now in our society, this was before this big movement of looking at the police critically. And so it wasn't as easy as just asking. You really have to start in the beginning by asking questions of your jury, of what their thoughts are on police, and who polices the police, and what their involvement should be. And we were able to get into that. I was able to get I thought a lot of good jurors that were willing to listen and look at police work through a critical lens, not necessarily someone who hates cops or hates the police, but understands that they do a job and that they have to do that job correctly, or else there should be consequences. So having that video and being able to play that and cross-examine the officers on that was great, because oftentimes they don't remember their own words. They don't remember saying that. So bringing that forward and then being able to ask them about that was very powerful.
That sounds like a huge win during the cross-exam, and especially that you were able to capture that audio, because as most of us know, there's like a 30-second window of silence where the cameras are on, but we're not able to hear the audio, and officers are also scary good at turning off their cameras at the right moment that quote unquote protocols allows, or when they're talking to their even it allows them to, even in certain moments, it allows them to talk to themselves about the current arrest and situation, but we as viewers of the body worn aren't privy to that, which is why it allows them to turn it off. So the fact that was captured, admitted, and elicited sounds like a huge win. And it got me thinking, after you were able to essentially extract that that testimony during your cross-examination, which seems to pair up really well with your overall theme that, there was really no evidence that she did these acts. It's really just evidence of the police targeting her. Were you able to have any success, or, what were the arguments like at the midway point during the 1118 motion?
Yeah, so and kind of circling back on that, the search for the truth, or the search for someone to blame theme, we hit on the search for someone to blame, and then I sort of started spinning it as there really wasn't a search for the truth in this case. My client was guilty from the start, and we know that because of these video clips, right? Before these officers are even on scene, they know that it's got to be my client, right? You're going to hear that from them. And so we started then with this sort of, there was no search. And through the trial, through the witnesses, it really did become evident that no one had actually seen her do this. There was all these little pieces of what we call circumstantial evidence, right? Nothing directly showing or proving that she did it. No video surveillance or anything like that, which there isn't always all the time, but no witnesses to her actual writing. It was just all these officers saying that it was her with nothing to really back it up. And so that was our argument at the 1118, which is basically a motion after the district attorney presents their case that's made by the defense, in which you ask the judge to dismiss the case or a count or multiple counts because there is such a lack of evidence that it shouldn't go to the jury. So you can ask the judge to get rid of the case if the judge agrees that the jury shouldn't even decide it. So in this case, I really hung on no actual witnesses. The only officers who admitted themselves that the lettering that they had said was my client's nickname was not actually, it didn't actually look like that, and that they had no formal training. But despite all of those arguments, the judge felt that there was at least a possibility that a reasonable jury could find it was her based on the evidence that was presented. So he sort of gave me a nod that we had made a decent case, but he wasn't ready to take it away from the jury at that time. So our case in chief started at that time.
Let me say that 1118s are always super tough, and judges really, really don't want to get involved. I will say, if anyone's interested in hearing about an amazing 1118 result, then go check out one of our previous episodes, the People v. DV Strangulation, where that attorney was able to get half of the entire complaint dismissed at the 1118 argument. And so it does happen in rare situations. But Derek led us to the next phase of the trial, which is after the prosecution completes their case in chief and there's a decision as to the 1118, the defense, in rare occasions, also gets to do a case in chief. And so, Derek, in this case, did the defense actually have one, and what was it?
Yes, we did. It was my client had told me from the beginning that she wanted to testify. Now, at this time, I was still pretty nervous about putting my client on. I hadn't had a lot of trials at that time where a client had testified, especially a client like this one who was very animated. We got along very well, but I don't think she got along very well with a lot of people. Can be sort of difficult at times. So I had some reservations about putting her on the stand after going through, all of that case in chief, which really was about 3 days. It ended up being about 3 days worth of trial. But ultimately, we did put client on the stand, and ultimately, my nerves really aren't the deciding factor. It's always the client's right to decide whether or not to testify. But she did want to testify. That was something she had said from the beginning. Again, I was a little worried she would start letting her anger dictate her testimony. I was worried she would start getting fired up about the officers and thinking about the arrests and having a prosecutor question you about that. But she ultimately took the stand. I led her through a direct examination where I had her basically recount as much as we could get into with the judge, a good amount or a portion of her history with the officers, being arrested by these officers, and then her, I would say, involvement in this particular area of town. She was known there. She did live in that area, and I wanted to paint with her a picture of someone who that was transient. She was still a person that cared about people and the community, and she led beach cleanups at the beach for months. She would do things like pick up trash on a daily basis for hours at a time and lead these trash pickups. And so when I had her testify, I really wanted her to talk about things like that, and also her art. I think they really wanted her to look like someone who was out just tagging all over things, when really that was sort of a mischaracterization. She was a longtime artist. She was really into music. She had drawn paintings. She sold her paintings. She sold her artwork at the beach. She did a lot of things like that was not in the police reports, that they didn't bother to ask her or find out about her before deciding that all this random graffiti was done by her. They took that one look at her cart. They saw art supplies, and they instead of asking her about the art, they assume it's her tagging all over, right? So that was a big part of her testimony, and she did well. She testified well. She endured cross-examination extremely well. Didn't get flustered, which is very easy to do when you're being cross-examined by a veteran attorney, someone who goes to trial a lot. And this particular case, the prosecutor was the head of that division, so this is someone who was extremely well versed in this area, and client held her own. She did well, and that actually came out in the verdict and afterwards in talking to the jury.
Well, we're definitely excited to get there, and I know we're creeping up towards that part of the trial. And I do want to take a moment that sounded like such a powerful direct, that in a case that seemed to be nothing but trying to badmouth and depict client in just a very negative, homeless, burden limelight, to spin it and give humanity to the individual that the client is. And that's our job. We're the only people oftentimes that are in our clients' corners and who get to know them better than anyone. And we need to find a way to get that testimony into evidence and throughout the trial so that jurors have all of that perspective when making their decision. So after you had that successful direct, how did that impact the closing? What were you primarily focusing on? And, why don't you walk us through how you delivered it?
So the closing was, by that time, we had really gotten right at closing. All the evidence is received, and my job really as her public defender is to wrap everything up and argue, right? Not rehash everything I had told them, but just argue. So I started my closing the same way I had started my opening, with the search for someone to blame is always successful, and it's not always just. And I went into, now that the jury had heard and heard the evidence, seen the photos that they were alleging was her, that they had now seen that there was no search. It was over long before it started, right? These officers, here they are, the same part of town, same person they've seen, and then they see some graffiti. There's no search. It's got to be her. Then they come out later with with another officer and another person who had never seen my client drawing on anything or tagging on anything. And they take pictures of graffiti and pin it on her. Again, no one sees her do it. No one knows her handwriting or her anything like that. So I obviously, in closing, one of the biggest things I always hit on is the presumption of innocence. That the notion that every defendant in our criminal justice system is presumed innocent, not presumed guilty. And that was really the bread and butter of the case. I did a PowerPoint in this case, which I've become more of a fan of PowerPoints in closings, because I really do think in this day and age, we are such a visual society that it really does help to have talking points at least, and not always, not something lame and obvious like the elements of a crime like the prosecutors use, but actual talking points. So I remember I had this slide, and it said, "What did the search for the truth reveal?" And then I put up all these bullet points. No civilian witnesses to the vandalism, no police officer witnesses to any vandalism, no handwriting match, no investigation into any other vandalism suspects, right? No search into any other potential handwriting matches, no collection or impound or production in court of any of the tagging tools she supposedly used. These were all black and white pictures that they had brought up. No showing of any intent by my client to use those tagging tools, right? Or those art pieces. She never said, yeah, I was gonna write on that, or yeah, I write. She never said anything like that. We also disputed the methamphetamine pipe at the time, and we had talked about things like that.
I love that you focused on the presumption of innocence, because what's so odd, and that I think most of people overlook, is that the presumption of innocence is easily defeated by probable cause. Because probable cause is the only thing that officers need to arrest an individual, and so often in life, in times, and in trial, when an individual is sitting at a table that says defendant after they've been arrested by the police, the jurors, society, their mind doesn't think innocent until proven guilty. It's show me where the cops did something wrong. Show me how this doesn't amount to reasonable doubt. And so for you to focus on that, and for the jurors to be able to accept that and internalize that and say, look, the officers were doing their thing based on probable cause. What I'm being asked to do is based on a completely different standard. And I'm now being forced to look at this client and these facts and these circumstances through a completely different lens than what the officers were required to do. So that sounds like such a huge point, and one that would be very persuasive given what we've heard over the last hour, these sets of facts, this client's background. And so ultimately, let's get to it. One of the things that everyone wants to hear at the end of the trial is, what was the verdict in this case?
So the verdict was split. And that's actually, one of the things that sort of made this an interesting trial, because we often think of that you have to beat all the counts to win and get a good result, or it was one of those. So she was found not guilty of all but one of the vandalisms. So the jury really stuck to the fact that there was graffiti all over these walls before. There were no witnesses to this. The one graffiti count that they did G her up on, find her guilty of, was for a writing on a concrete bench that was done in pencil. And the jury actually gave a jury note. They had a jury note, which I'm sure you've covered on an episode thus far. But the jury, when they're deliberating, has the ability to ask questions that go to the judge, and then the judge brings the attorneys in, and then the attorneys and the judge figure out a response to send to the jury. And so the jury had come up with a question asking if they could find her guilty of a vandalism, even though it was done in pencil. And so it was interesting because, it's sort of an insight into the jury's mind when you get these notes. And so it seemed like they had been talking about, whether that's really something that they could, is that really vandalism if it's done with pencil and if you can wipe it off, basically. And so we had a big old argument with the judge and the prosecutor about how to answer it. My position was that it should not be, because it actually is removable. The judge didn't agree, and they answered the question with one word, yes. So she was found guilty of one count of vandalism, and she was found guilty of the possession of of the narcotics and being under the influence of methamphetamine.
Well, despite obviously some of the convictions, congratulations first and foremost on the not guilties, especially like as we talked about in a case that was so difficult from the start and has such negative limelight and kind of just a presumption of guilt written all over it based on client and her prior activity. And so well deserved. And I want you to explain to the members of the jury why you walked away from this case feeling victorious.
Well, I think I felt the most victorious in this case because even though we had lost some counts, and really this case got pretty interesting at sentencing as well, which we can get into a little bit. But this was a woman who had really been thrown in and out. I mean, she had been in and out of custody. She had never decided fully to go to trial. She had always been, in that situation of being in custody for a couple of days. And, the alternative of going to trial or getting out of jail, it was always get out of jail. She was not in a good place. And on that same token, she knew that what was happening to her was wrong, and she wanted to take a stand. And there's a lot of people, a lot of voices that aren't heard, that are harassed, that are put into these situations with police, and their voices aren't often heard. And it takes a certain person and a certain individual to really have the guts to stand up and take something to the box and go to trial on it. And even if you're knowing that you're going to lose a couple of counts, right? We knew we were going to lose the possession of a meth pipe count, but we wanted to go to trial anyway. And she wanted to go to trial to prove her story and to prove her point that, just because you saw me and what I may have been like in the past, it doesn't make it me, right? And on this particular occasion, the jury agreed. And it was really just standing up and saying, look, you got this wrong. This wasn't her. There's graffiti there. And just because you don't like her, you can't pin all this on her. And really getting her voice out, and having the courage for her to go through a trial in custody, and get up on a stand in front of a jury that you don't know, and these random people, and tell your story from that point of view is very genuine. And it's something you don't get to see a lot. And it's something that I really felt, it was one of the, although a split verdict and things we had to deal with sentencing after, I think it made a difference in her life more so than any other person I have gotten to the privilege to take to trial.
Amen, brother. That was so beautifully said, and you should feel victorious after that situation. Now, one of the things you said in your answer was perfect as well, because as we wrap up the show, and I know you mentioned you might want to touch on the sentencing, and I think the this might be an opportunity for you to do so. But you talked about how, she wanted her day in court. She wanted to take this matter to the box. And that's never necessarily an easy decision for a client and an attorney to make. Taking a matter to the box is a battle. And so I want you to explain to the members of our jury, to you, what is the significance of that spirit of taking it to the box?
Well, I think it's everything, man. I think it's one of the only true ways that we as citizens in this country and believers in freedom and the right to independence, it's the only way that we can utilize that and the only way to check our government. And you may not be a person that believes that the government is out to get us or is hurting us, but on that same token, we all have a responsibility to get our hands in and make sure that this system is working. And whether it's a blue collar or a millionaire, it doesn't matter. The trial's the same, your day in court's the same, and your ability to stand up and fight only comes really in that arena. And I've been really lucky enough to do a lot of trials now with multiple clients, people from all over the world, different countries, and it's really the last place where everyone can have the same voice. It doesn't matter who you are, or who your dad is, or who your mother is, or who you like, or who your boyfriend is, or what they look like. When you're in that seat and I'm sitting next to you and you're a defendant, you have the same voice no matter who you are. And that's what I think is important. And I feel like as public defenders, we get the privilege of preserving that voice and making sure it's heard, and that it continues to be heard, and that we're not just thrown out to the side, and just letting prosecutors and judges do whatever they want with people, because it's a big fight, and the cards are stacked against us. So I'm a big believer in taking it to the box and fighting for what you believe in and fighting for your rights, because once something is taken away, it's almost impossible to get back. So you got to fight for your rights.
Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. The information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.